We saw the first three canons yesterday. 10:55, 56, 57 consent. I'll give sufficient time for the questioning later on. We now straight away take the next canon, that is canon 1058, 1058. It speaks about jus connubii, that means right to marriage. Right to marriage. Everyone has the right to marry the person of his choice. It is one of the fundamental rights, like right to live, right to education, right to good name. The canon here speaks about right to marriage. So look at the wording of the canon. All can contract marriage who are not prohibited by law. So all can contract marriage who are not prohibited by law. In the history, maybe some terrible kings denied such a right, and then sometimes even some men were castrated and things like that. But then the church once again in this canon affirms the right of persons to marry the person of their choice. But sometimes they are prohibited by law. As we said, the 12 impediments, 1083 to 1094. So they are prohibited by law. Sometimes those who cannot give consent, as in 1095, they are prohibited by law. Somebody who has already married and has a spouse are prohibited by law. We have to understand it as prohibited by law. Sometimes when the law prohibits, it may make the marriage invalid, as the 12 impediments. Sometimes the law prohibits but only unlawful. Sometimes it is only unlawful but not invalid. Simple example is, if a Catholic marries a non-baptized, then Hindu, then the marriage is invalid without the dispensation. Suppose without the permission, if you marry a Protestant, a baptized non-Catholic, then it is only unlawful. So both are prohibitions. One makes it invalid, another makes it only unlawful. Against the law, but still the marriage is valid. You know, in canon law often we speak of this distinction. One example is, see, if you celebrate Mass without vestment, it is unlawful but valid. If you celebrate Mass without bread and wine, it is not only unlawful but also invalid. Like that, invalid, unlawful. So, all those who are not prohibited by law cannot marry. All those who are not can marry, who are not prohibited by law can marry. So it is a fundamental right. That's why those days people were insisting, when a Catholic wants to marry a Hindu or Protestant, you cannot marry at all. Now also prohibition is there, but fundamentally the right to marry prevails. So the church makes certain precautionary measures and then allows them to marry. What we call disparity of cult marriages and mixed marriages. We will study about them later broadly. Ultimately, nobody can be compelled to marry. One thing, it is right. Secondly, nobody can be compelled to marry a person he doesn't want, she doesn't want. These are fundamental rights. That's why this canon once again affirms the right of each and every human being to marry, provided he has the necessary age and then knowledge and freedom. Okay. We go to the next canon. Canon 1059. 1059 speaks about the competence of the church with regard to marriage. Competence of the church with regard to marriage. Any word in the canon, if you don't understand, you have to ask me. Otherwise, I will think you know it. When I ask you, you should not say, I don't know, Father. The marriage of Catholics, even if only one party is a Catholic, it is not necessary both must be Catholic. Even when one is Catholic, he comes under the laws of the Catholic Church. So the marriage of Catholics, even if only one party is a Catholic, is governed not only by divine law, but also by canon law. So you are governed by divine law, but also by canon law. Without prejudice to the competence of the civil authority in respect of merely civil effects of marriage. So in this canon, we hear about divine law. The 10 commandments are divine law. There is no doubt about it. Unity and indissolubility are divine law. Unity and indissolubility are divine law. So, plus canon law. For example, God did not say priests should not marry. Church law says priests should not marry. Religious should not marry. So, some of the impediments are also by merely canon law. Canon law. So, so many things. In this code also, there is divine law and also canon law. Merely ecclesiastical laws means they are not made by God Himself. The church, in order to observe the divine law, gives additional laws. So we are bound, for example, writing of the banns, proclamation of the banns, canonical form. So all these are man-made laws. All the laws made by the competent authority of the church, not the laws that come from divine revelation, are called merely ecclesiastical laws, canon law. Sometimes canon law repeats the divine law. Sometimes canon law gives a new law other than the divine law. So we are bound to follow not only divine law but also canon law. Who has to follow? When those who marry are Catholics, are Catholic and Protestant, are Catholic and Hindu. Because one party is Catholic means you have to follow the divine law and the canon law. The next question is, what about civil law? So, merely civil effects of marriage, especially with regard to inheriting properties and so on. So sometimes the compensation to be given in cases of the breakup of the marriage. So all these things we don't have police power to enforce it. So we come under the civil. Sometimes civil law requires that our marriages blessed in the church are registered there. We have to follow the civil law. It has to be the entry has to be sent to them as and when civil government requires. So we have to follow civil law. One basic principle with regard to civil law, Canon 22 and also Canon 1290. So what is it? These are called canonization of civil law. Canonization of civil law. Someone read Canon 22. Canon 22. In the general norms, you study that. Very important canon.
Canon 22. When the law of the church remits some issue to the civil law, the latter is to be observed with the same effects in canon law.
Okay. The latter is to be observed. That means civil law is to be observed with the same effects in canon law. Only two exceptions are there in the last part of the canon. So we have to observe civil law as though it were canon law. We think it is given by God, given by the church. Like that we have to follow. Civil law says you should have driving license before you take the vehicle. As though it were canon law, you have to follow. Civil law says you have to get permission for putting up a new building. You have to follow as though it were canon law. But two exceptions. What are the two exceptions? When the civil law is contrary to divine law. When the civil law is contrary to divine law. Example, legalization of abortion in many countries. Civil law permits, canon law cannot permit, divine law is against it. So, especially divine law is against it. Thou shalt not kill is God's command. So, when the civil law. Then same-sex marriages. In some countries, civil law may permit, but divine law will not permit. So, euthanasia and things like that. So, you cannot accept. Or legalization of prostitution. Canon law cannot permit it. Divine law cannot permit it. So, in this case, Father said we have to follow all the civil laws. No. When the civil law is against divine law, we should not follow it. Another thing, some things are left to canon law itself by the civil law. Civil law leaves some matters to canon law, or civil law recognizes canon law in some matters. Yeah, as in some countries, personal law is respected by the civil law. So in that case, we can make use of canon law. For example, civil law recognizes our parish priests as registrars of marriage. So, we have the marriage celebrated in the church. So, except in these two cases, civil law must always be followed. Civil law must be followed. So, here also, merely civil effects of marriage are under the authority of the civil law. That's why we say always, whenever they come for the church tribunal, we also ask them to go to the civil tribunal. Because you may say they are no more husband and wife. But civilly they continue to be. While civil law recognizes our marriage, this is an important sentence here. Civil law recognizes the marriage blessed in the church. But civil law does not recognize the dissolution or annulment given by the church. Civil law in India does not recognize. So, even though the marriage is declared invalid in the church tribunal, you should never bless a marriage before ensuring that the marriage is also civilly divorced. Civilly, that the parties are civilly free. We don't call divorce in the church. We say declaration of nullity or dissolution by the Holy Father, mainly. But civil law uses the word divorce. So, civilly the parties must be free. Only then you can go for the second marriage. In such a situation, the second marriage will be canonically valid but civilly invalid. Civil law can punish us for going with the marriage when the first marriage it retains as valid.
What the church calls for divorce? What the church calls for divorce?
No. What I am saying is, one is in the church we use the word, for example, nullity of the marriage. That means the marriage is declared null, invalid. One thing. Second is the Holy Father, I said some cases, non-sacramental marriage and non-consummated marriage can be dissolved. Valid. Dissolution of the marriage. valid marriage but dissolved, because it is non-sacramental one case, another is non-consummated marriage, dissolution of the marriage. One more thing also, what we call Pauline privilege. Paul himself said that because of baptism one party goes away, then the other party need not be celibate lifelong. So the other party can marry a baptized person. So in that case, the first marriage will be declared invalid, will be dissolved by the second marriage. Not by baptism and the second marriage. That is called Pauline privilege. Pauline privilege. Dissolution is, here the marriage is invalid. Okay, on the three grounds we saw yesterday. Dissolution is, it is valid marriage, but it is dissolved by the Pope or by the Pauline privilege. Dissolved by the Pope or by the Pauline privilege.
In the case, otherwise, here when the church has dissolved, but the court has not accepted.
Not accepted.
In other case, when the court has accepted this one divorce, whether the law will abide for the church.
So the church, when the court has given divorce, you cannot go for a new marriage in the church unless our ecclesiastical court also declares the marriage invalid.
Otherwise, they are still husband and wife in the sight of the church unless the church declares them otherwise.
Yeah. So many people, that's why now we have a problem of taking care of the people. Many are civilly divorced, but ecclesiastically they are not free to marry. As I said, civil law permits by mutual consent, one example, but canon law does not permit divorce mutual consent. So how to take care of them? Only when we find a ground for their invalid marriage in the church, our church must declare the marriage invalid or apply to the Pope in some cases and get the dissolution. So to marry a second time for the church, you should be free first by the side of the church, second by the side of the civil law.
When we speak about the laws, we say that divine law and civil law are the most important ones for Christians.
Yeah.
And, divine law and canon law.
Canon law, yeah, and also
the civil law. So now in this case, when the civil law is already acting out, and since we are off the place, will it not apply to us, or in that case we have to apply to
No, you are civilly free, but ecclesiastically not free. Civil law you can give money also and then get a divorce. In the church also, in the past, they were pretending that the marriage is invalid and then came to the ecclesiastical tribunal. At that time only they started with a new officer, that is defender of the bond, who must argue in favor of the sacrament. Even if the man and woman agree, we have to protect the dignity of the sacrament. You want a new man, she wants a new woman, he wants a new woman, so for that sake we cannot. So, the civil law will not force us to bless the marriage of anybody. We can bless the marriage only according to our law. According to our law. So that's what you may be thinking, that the civil law has allowed. Why do you say like this? No. We can never accept it. We can never accept it. Because we have to follow both canon law and civil law. Civil law should not be followed in some cases like that. That's it. Even if civilly you are free, that's what I said. For any marriage, we need three things. Once again and again we go back to this point only. Consent, free from impediments, and the canonical form. So this is needed on the part of the church. Now the church, suppose somebody is earlier married, the church will not accept the divorce because according to the church, prior bond is still there. Civil law has no power to break the prior bond. Civil law. Only Holy Father can break if it is non-sacramental and non-consummated. If it is sacramental and consummated, nobody can break it. We can never allow the marriage. But at the same time, even if the church has declared the marriage invalid, again another parish priest celebrates the marriage, second marriage. It is valid, but in civil law it is not valid. You are violating the civil law. Civil law can punish you. Civil law can punish you. So see to it that they are civilly free.
But then in that case, who will be held responsible? Will it be the judge, curia, or the couple there?
Which one?
Now, when the civil
When they marry, you are both will be held responsible. You are the officiating minister for a new marriage. The couple also can be the first party. Like that it has happened in India also. Some people, the ecclesiastical, there were cases. I was also called to the court. A very big man, church ecclesiastical tribunal. Then it gave the marriage is invalid because forced marriage. Civilly they did not get it. Then the first wife filed the case and claimed so many lakhs of compensation. The priest called me, Father, we have to argue that our nullity, our judgment is recognized civilly, Father. You have to work, Father. You are the canonist, Father. That is all right, I agree. But then, what you did is wrong. I teach my students very clearly. You have to see whether the parties are civilly free. Otherwise, you cannot marry them in the church. I have told you so many times. Now, after you have been fined, you are telling me we have to fight for it. They discussed in the bishops' conference, there is other problem. For the Catholics, okay, big group. There are small churches. Every pastor will declare for 100 people the marriage is invalid. What will we do? There is no proper procedure. For the government, everybody is the same. Every little community of faithful is the same. If that is to be recognized by civil law, there will be confusion. That's why it did not make much headway, much progress. Okay.
In case in our parish there is a family, the husband and wife always fighting, and then the problem is never ending, and all about their children are affected.
Yeah.
Now they come to you,
Yeah.
your parish, they come to you and they say that we don't want to live together.
Yeah.
And then we have dissolved the marriage in the civil.
Civil divorce obtained.
They have already got a civil divorce. Now they want to tell that we want to dissolve our marriage. Now how will you proceed?
So you are coming to the conclusion of our class. Now how to go about? We have to study all that. Now how to go? There was canonical form. Then there was no impediment. There was no impediment. Problem is with the consent.
Now in the beginning they had given consent.
Yeah, beginning they might have given consent. Then you can never declare the marriage invalid. But when there is danger to life, we can separate them, but the bond remains. Our separation doesn't have much value. Only civil separation has more value. There is one section in what we are going to study. Separation while the bond remains. You may say in the beginning, there may be 10 children also. 10 children also, but still the marriage can be invalid on the basis of false consent. Father, I did not know this, Father. Had I known, I would not have married, Father. Then afterwards he compelled me. How you had all this compelled me, Father? No problem. Validity of the marriage does not depend on the number of children. Validity of the marriage depends on the proper consent. In your case, There can be a ground found on the invalidity of the consent. You have to help them if it is possible. If in all these three it cannot come, then you can only ask them to live separate. Only that we don't allow them to remarry, because bond remains. Bond remains. Okay. So you are asking questions for the end, but now we will go little by little. Some questions will come as it is. Now we go to the three laws that we have to follow. I am happy I gave me an occasion for you to give the importance of civil law again and again, especially book 5, Temporal Goods of the Church. Follow meticulously all the civil law. Buying property, selling property, registering property, paying the tax, paying the employees, everything, especially duties of the administrators, that means bursars and procurators. 1284 very clearly says, follow the civil law. Don't cause harm to the church because you don't observe the civil law. Everything, insurance contracts, everything is described. Canon 1284 especially, follow the civil law. So many people do not follow the civil law and cause harm to the church. Now we go to the next, 1260. So, marriage enjoys the favor of the law. In doubt, the validity of a marriage must be upheld until the contrary is proven. So, whenever a marriage is celebrated according to the law, law means all three, divine law, canon law and civil law. We presume that the marriage is valid and lawful. Presume means we suppose, or presumption is nothing but probable conjecture. That means we think the marriage is valid. So two people are coming, the woman is with the thali, going by two-wheeler. We think they are married and then their marriage is invalid. Don't think it is invalid marriage. Marriage is valid. Whenever you see a couple, don't give them idea, maybe your marriage is invalid. They are living happily. So, marriage enjoys the favor of the law. Whenever there is doubt also, we think that the marriage is valid. If it is proved, on the basis of the three again, that's why I gave that point already yesterday, that there was an impediment, that which was not dispensed, that one of them was forced into marriage or cheated into marriage. If it is proved, then it will be invalid. Then there was no priest or a priest who did not have the faculty bless the marriage. If it is proved, the marriage is invalid. Otherwise, we presume marriage is valid. Always we think in favor of marriage. Presumption. So the code in a number of canons uses the word presumption. Later on another canon will say about presumption also. Presumption is supposition. We guess it. We think in favor of this. When there is doubt, it favors the validity. Cricket. When there is doubt in the mind of the umpire, he must favor the batsman, not the bowler. He should not declare the batsman out. When you think whether the marriage is valid or not, you should think marriage is valid. That is it. The umpire favors the batsman when there is a doubt. Like that canon also says, I think 1052. When there is doubt with regard to the vocation of a seminarian, the doubt favors the church, not the seminarian. So you should be sent out. When there is a doubt whether he is suitable or not, when there is a doubt whether he is suitable or not, then the seminarian is not to be promoted. Doubt. In case of doubt regarding the vocation, doubt favors the church. Doubt favors the church. Okay, simple example. Early in the morning, 5 o'clock, the light is burning in your room. Presumption is that you are already got up. But presumption yields to contrary proof that you are snoring also, light is burning. Then we know, yes, we thought in favor of you are getting up already. But then presumption yields to contrary proof. We think it is valid. The girl says, at gunpoint he tied the tali. Then we know that it is invalid. So presumption yields to contrary proof. We think that he is awake, but it is proved. But normally whenever there is light, we think that the person is awake. So marriage enjoys the favor of the law. So many marriages may be in fact invalid. Cheated marriage. So during marriage they cheat, consent, we will see that also. The boy's father said it seems, so my son is standing on one leg to marry your daughter. Finally he had only one leg only. In Tamil they say, Vatta kalle nikkiran. He had only one leg only. Then the girl's father told it seems, my girl also has an eye on your son. She had only one eye only. Enga ponnukum unga paiyan mela oru kannu dhaan. She had only one. So on the day of marriage only they find out he has only one leg. She had only one eye. So did I not tell you my boy is standing on one leg to marry your daughter? Marry your daughter. Did I not tell you? Like that they may say so many things. And then to arrange the marriage. Then the consent will be affected. Cheated marriage. Had I known like that. Like that whenever the marriage cases come also. So one lady came, it seems. He cheated me into marriage. Please give me divorce. But she brought with her 5 children. How he cheated you into marriage? You want to have a divorce. How long were you living together? The woman said, it seems for the last 10 years. 10 years. What you said all the time fighting? And then how these 5 children were born? Then she said, it seems. He used to come once in a way to ask pardon. Every time he asked pardon on one child, I said. Like that. That means it was not real cheating. She forgave him. Accepted him as the husband. So it was not real cheating. So you should know whether what they claim concerning the validity of the consent is valid or invalid. So like that so many things we will see. So this is Canon 1060. Marriage enjoys the favor of the law. That is Canon 1060. Favor juris. The favor of law is on the side of the validity of the marriage. Then we come to different kinds of marriages with regard to their effect. When is the first hour break?
5 more minutes.
5 more minutes. Okay. I will say this also. We speak of all marriages having a natural bond. We call it natural bond. Natural bond. There is a sacramental bond when both parties are baptized. Sacramental. A marriage becomes a sacrament When both are baptized. I don't say both are Catholics, but both are baptized. Both are baptized. Catholic, Catholic and baptized non-Catholic. So, or two non-Catholics who are baptized also, when they validly marry according to their law, then it is a sacramental bond. So, this is called marriage, that is ratum, and there is a sacramental bond, it is ratum. Ratum in Latin. A ratified marriage. A ratified marriage. Firmly strengthened by the sacrament. A sacramental marriage. Then, if a ratum marriage, after a ratum marriage, if they had sexual intercourse, the man and woman, then it is consummated. It is a marriage that is consummated. Consummated in a human manner. That's also important. Suppose somebody is given some sedative and then unconscious, then we cannot call it really consummated. They must be in their faculties. Somebody is forced, then also it is not done in a human manner. So, when it is consummated in a human manner, it is called ratum et consummatum. Ratum et consummatum. Ratum et consummatum. Ratified marriage and consummated marriage. A marriage is merely ratified when it is not yet consummated. A ratified marriage, if will be called a ratified and consummated marriage, if after the marriage the parties, had a sexual intercourse. So canonically, what constitutes consummation? On the part of the man, there are three acts. Erection of the male organ, penetration of the male organ into the vagina, and then the third is ejaculation. Ejaculation of the semen. So these are the three things that is needed on the part of the man. If any of the one thing is missing, then the marriage is not really consummated. The marriage is not consummated. On the part of the woman, the female organ of the vagina must be in a position to receive the male organ. That's all. So sometimes people will confuse potency with fertility. We do not worry about fertility, whether the man is fertile or woman is fertile, whether there is semen which can give life, that doesn't matter. That doesn't matter. So fertility is not important, but the ability to perform the sexual act is important. This is what we call it consummation. Sometimes when you go to the civil doctors, they think somebody is important because there is no child. No. Sexual act is performed, both accept. That means the marriage is valid, the marriage is sacramental. No problem, he is not suffering from impotency. Impotency. What is potency? Here the canon speaks about the kinds. For example, a valid marriage between baptized person is said to be merely ratified if it is not consummated. Ratified and consummated. Look at the canon. look at the canon. Ratified and consummated if the spouses have, note the word, in a human manner, engaged together in a conjugal act, in itself apt for the generation of offspring. So, the sexual act is apt for the generation of offspring. Okay. To this act, marriage is by its nature ordered and by its spouses become one flesh. Here some more explanation. Marriage is for the procreation of the children and it is one of the purposes of marriage. They become one flesh through the sexual act. So, this is what is explained. What is merely ratified marriage? What is ratified and consummated marriage? A ratified marriage is a sacramental marriage. It becomes consummated when they engaged in the sexual intercourse in the human manner. This act makes them one body and they are trying this for the procreation of the children. That's it. I'll read the next paragraph also. Okay, we'll have the break, then we'll stop.